Hello, happy Tuesday, everyone. Welcome, welcome. Wow, what a large crowd. I think this may be our highest attended webinar so far. Okay, I'm just gonna, before we jump in, don't worry, I'm not gonna call on anyone yet. I just kind of want to get a pulse check before I do intros and jump in. I don't know about you, but like when we decided to put out this webinar, like my heart started racing, like, oh, are we really going to talk about this? Can I get a +1 in the comments if there was anyone else who saw this topic and was like, can we talk about this? Are we allowed to? Can we ask these questions? Can we say these things aloud? Okay, yeah. Okay. So glad to know that I'm not the only one who felt just like a little bit of heart palpitations. Know that you are not alone. Look at everybody in the comments who is just like, ah, and I just want to like acknowledge it's a real thing, right? Because HR teams can work in such silos and we talk about such scary, confidential, life impacting things that it can be scary to talk about. And then you worry that you're the only one wondering these things. And then you wonder, like, is there anyone that you can reach out to help for on these things? So I just want to say welcome. I'm really excited that we are creating and sharing this space together today. Let me introduce myself and the webinar, and then I'll introduce our lovely guest, Justine, our lovely legal expert hosting with us. My name is Melanie Naranjo. I head up the people team here at Athena. We are a compliance training company. And so as you can imagine, reasonable accommodations is one of the things that we talk about in our compliance training and one of the things that we manage in our case management tool. And so, after talking and partnering with so many people in the HR space, including myself and my network, we realized this is a really big topic that not enough people are talking about. And so we decided to put this webinar together. For anyone who's new to one of my webinars, know that they are very interactive. And part of the joy and benefit of these webinars, yes, like a good chunk of it is the content, but a good chunk of it is truly the network and community that you build in the comments. So please be real, be open, chat, share your LinkedIn link if you want to connect with anyone. Oop, let me turn off my notifications, and really connect with anyone on this call. These are your HR peers that you can lean on. Also know that this is a safe space, right? And so we all really want to respect each other. Anything that you see in the comments, if you see a name, if you see a company name, please don't share this outside of this space. This is for us to really build HR community and have people to lean on. So with that said, Justine, our lovely legal expert, I'm going to ask you to, yes, unmute yourself. Let me share a little bit about how I met Justine and how awesome she is, and then I'll give it away to you to do a more formal introduction. Justine and I met a while back at an HR dinner, actually. It's an HR legal dinner. And then we went to a Yankees game together, and it was amazing. And we realized I know nothing about sports, but Justine is here to educate me. We're going to go watch a hockey game together sometime, and it's going to be an amazing experience. And in the meantime, I realized Justine is such an amazing down-to-earth lawyer that I absolutely needed to have her on this webinar. And so Justine, if you can tell just a little bit more about yourself, how you got to where you are today, and then we'll kick it off.
Melanie, we're not just going to a hockey game. We're going to a Philadelphia Flyers hockey game. I'm not just an employment lawyer. I'm a Philadelphia sports fan. So that probably starts me off on the wrong foot with a lot of people here. But listen, sports and employment law, those are my things. As Melanie said, I'm an employment lawyer at Ogletree Deakins. We're one of the largest employment law firms in the world. I do all things employment defense, right? So that means working with folks like you every day, defending employers, managers, HR professionals against employment litigations, and also, counseling them through some sticky situations that come up to try and prevent those lawsuits from happening in the first place. I'm hoping that today's webinar gives you some confidence, at least, to tackle one of those sticky scenarios, and that's reasonable accommodations, particularly when they're requested in connection with a performance issue. I will say, I recognize nothing is easy for HR. I know that because I work with people like you every day. I'm here to tell you, hang in there. We're going to get through all this together. That said, I did want to mention before we jump in, every reasonable accommodation issue is unique. Every single one is fact specific. No single one is the same as the other. There is no cookie cutter approach to any of this. None of what I give is legal advice. Did Melanie say that or not yet? In any event, it's not legal advice, but I hope it does give you a little bit of a roadmap and a little bit of confidence to tackle some of these individualized issues.
Love it. Great summary. And yes, absolutely. We're going to talk about some disclaimers because I don't want anybody here coming and saying we watched Melanie and Justine's webinar, and so that's how we decided what to do. That this is not formal legal advice. Don't worry, we'll talk about that in a second. All before we kick it off, I do want to share like one thing to keep in mind in the comments. Because I'm going to be interactive with you all, I will ask you to share responses in the comments. If you don't want to be called on, because I do call on people, I'll give you unmute access. Ace in the background is working tirelessly to make that work. Just put an asterisk next to your response, and that way I won't call on you. I don't want that. I don't want the fear of being called on to be a deterrent to participating. I get it. If you are an introvert, I'm right there with you, okay? Don't worry, I won't call on you. Just put an asterisk next to your response. Okay, with that said, all quick agenda. We're going to do disclaimers, as Justine mentioned. We're going to talk about reasonable accommodations. What are they? How do we navigate them? And then the big one that I think most of us are on this call for, which is how do we navigate these tricky situations when it overlaps with a performance issue, as they so often do? And then documentation. We'll spend just a little bit of time at the end talking about Athena and how we can help you with your reasonable accommodations in the workplace. And then at the end, we'll leave about 10 minutes for Q&A. With that said, let's go ahead and kick it off. Disclaimers, as Justine mentioned, I want to like have a whole slide where we just dedicate this to say, listen, Justine is an expert lawyer. If you want to lean on her legal services, we will be sharing Justine's contact information at the end of the webinar. But for the purposes of this webinar, this should not be taken as legal advice because, as Justine said, it is case by case. And so it is not possible for Justine to give you legal advice on this call because she's giving high level, broad advice. Justine, did I miss anything? I want to make sure from a lawyer perspective, I got you covered.
No, I think you said it. No attorney-client relationship. That covers it.
Love it. Okay, great. With that said, let's get into it. We're going to kick it off with one of my favorites, pulse check question in the comments. On a scale of 1 to 5, 5 being I super agree with this statement, 1 being I do not agree at all, I would like to know how much you all agree with the following statement. Feels like there's been an uptick in reasonable accommodation requests over the past few years. Fascinating. Look at these numbers coming in. Also, all like truly, this is the highest attended webinar we've ever had. You all are wild. I'm loving it. Clearly, we got to do more spicy topics, and it keeps coming in. Okay, so here's the thing. I'm gonna call on a couple of people, and then Justine, I'm gonna ask for your perspective because you actually gave me a very interesting thought before we jumped in here. So let me call on someone who didn't put an asterisk next to their response. Let's do Let's do Annette Livingston. Annette, Annette Livingston. Can you unmute yourself and tell me why this was a 5 for you? Why to you does it feel like there's been an uptick in reasonable accommodation requests?
Hi, can you hear me?
Yes, perfectly.
I work at a university that's affiliated with a hospital. And I've just seen a lot more. We're actually working on a training program now for reasonable accommodations because it's just become more frequent.
Wow. Okay. And so are you seeing, when you say they've become more frequent, do you feel like it's in the last year, in the last 5 years, since the pandemic? What is your sense?
Well, I've only been at this university for a little while, but in my previous position, I've also seen an increase. I would say it is noticeable since COVID.
Fascinating. All right. Annette, thank you so much. Everyone give Annette a round of applause in the comments because I don't know about you, but it's very scary speaking up publicly with like, quite frankly, like we have so many people on this call, but Annette, now you're like famous. Okay. So just Justine, can you unmute yourself? Because I'm curious to know when you see all of these 5s coming through in like rapid succession and with such high conviction, what goes through your mind as a lawyer? Is it true? Are we in fact seeing an uptick in reasonable accommodation requests?
I think the reality is that we're not seeing any more than we've seen in the past. But I think that we're seeing a particular type of one more than we've seen in the past, and that's the request to work from home, right? That's the request to telecommute as a reasonable accommodation. It could just be because of the nature of the beast that I practice in. You know, I've been dealing with reasonable accommodations as far back as I can remember since starting practicing. But I feel like that might be the reason why we feel like there's an uptick, because there's an uptick in a certain particular type of reasonable accommodation working from home since COVID.
That is just fascinating. It also makes me wonder, to be honest, if there are reasonable accommodation requests that are coming up that that people are not knowing enough to lean on a lawyer for, or that they're just doing on their. In fact, I'm not going to call anyone, but I'm curious to know in the comments. I promise I won't call. And I'm going to give you the out that it doesn't have to be related to your current company. But would you say that in your experience, you have done, or your companies in the past have done reasonable accommodation requests without partnering with a lawyer, an outside lawyer? Okay, so I'm seeing, oh, okay, the yeses are coming in. Okay, so that is fascinating too, right? That's really interesting. Justine, I already know your take, which is, of course, we should like be partnering with lawyers. Any thoughts on this before I jump into like more the meat and the potatoes of our session today?
I mean, look, I'm biased because I'm a lawyer, right? So I'm
Yeah.
going to say work with lawyers. But the reality is that the law, the case law on reasonable accommodations, specifically explicitly says that each reasonable accommodation request is individualized. Each one is unique. What might be considered a reasonable accommodation for one employee in one role at one location in one work environment with one disability may not be a reasonable accommodation for another one in a separate role, location with a separate disability. Unless you have the same one from the same employee in the same role with the same disciplinary background, you know, you really should be working with a lawyer. There really isn't a cookie cutter approach to any of these, but I recognize I'm biased.
Fascinating. And you know what? I bet if more HR people had bigger budgets, they would super be leaning more on lawyers. And I bet
Yeah,
that like, a lot of them are just like super strapped, which is another fascinating thing for us to think about.
yeah.
Okay, so with that said, I'm going to do our official pulse check question to help us cut into the, or like jump into the meat and potatoes of this. Yes, no in the comments. Remember, asterisk if you don't want to be called on. I've received formal training on how to effectively navigate reasonable accommodation requests. I'm just curious. I'm just curious. How many of us have been trained on this? And how many of us are just like, oh no, I guess I'm in HR, so I do this now. My goodness, I'm seeing some yeses, but I am seeing far too many no's. I'm gonna call on one person. I'll keep it brief. Don't worry, I'm not gonna talk about your company or any specifics there. It's gonna be more about like, I'm curious to get your perspective here. Let's call on someone with a no that didn't put an asterisk. Let's do Kristen Thomas, Kristin. I spell your name so the ace in the background can find you. Kristen Thomas, could you unmute yourself and just share? Okay, you said no. Can you walk me through like how scary it was to to navigate your first reasonable accommodation without any training?
Hi, can you hear me?
Perfectly.
Okay. Well, it was very scary. I think I would say years ago, maybe I don't know, 7 or 8 years ago, is new to HR back then. And I was working for a nonprofit, and it was just really I don't know, just kind of just having to go by my professional college knowledge and the employees, the tenured employees that were there within the company, to to accommodate, and because there was no legal counsel back then at that company. It was just senior management, senior leadership. So very scary.
I really, really appreciate you sharing that, Kristen. Thank you so much. I want to put out there for the HR perspective and anyone who's experienced this, who is struggling with this, who, maybe doesn't feel comfortable talking about this. I want to share like how hard and unfair that is both to you and to your employees. To your employees, because how can you feel confident that you are giving them the best support possible if you've never received formal training? And to yourself, because you're being put in this really tough position where you now are literally responsible for this potential real life impact on someone. And you're also worried about if you're protecting the company adequately and if you're handling this appropriately. And so I just want to say that's really, really tough. And so what I'd like to do is let's jump into it and make sure that over the course of this session, you walk away with some like genuinely helpful tactical tips, pitfalls to avoid, strategies to lean into, and of course, how to navigate the balance between reasonable accommodations and performance management issues. So I'm gonna go ahead and stop sharing for a second, so that we can just see Justine's lovely face as we do this. Oh, am I gonna figure out how to stop sharing? Yes, I am. All right, love it. Okay, so with that said, Justine, I'm curious to know, can you, for the audience, help us define what exactly is a reasonable accommodation and what qualifies as one?
Yeah, so to just say up front, a lot of employers know generally that they can be sued, they can get in trouble for engaging in disability discrimination, right? Discriminating against an employee who has a disability. Not only can they be sued for doing that, but they also affirmatively have an obligation under those anti-discrimination statutes to reasonably accommodate an employee. So even if you don't fire an employee or you don't take an adverse action against an employee, your failure to accommodate could also form the basis of a cause of action in and of itself, a separate cause of action. What is a reasonable accommodation? Okay, there's two words here, reasonable and accommodation, right? Generally, an accommodation in the context of job performance, right, is any change to the work environment or the way things are customarily done or the way that the job is customarily performed that enables an otherwise qualified individual with a disability to perform those essential functions of the job, right? That's generally what an accommodation is, a slight change or adjustment, right? Reasonable means generally two things. One, it's reasonable on its face, meaning doable, feasible, plausible, right? And two, that it's effective, meaning it meets the needs of the individual by providing them the help that their disability causes them to need, right? Or eliminates the barrier that their disability poses for them, right? An accommodation could be considered not reasonable because it's not effective, right? I can certainly get into some examples if you'd like, but that's the answer. What is a reasonable accommodation from a general sense?
So let me make sure I'm like saying the explicit thing that I think many people wonder, which is, to be clear, are employees required to accommodate all requests?
No.
No. Okay.
No, they're not. And there's generally, I'll say, three reasons as to why, right? First of all, there's a reason why the word reasonable is used in this phrase, right? And it's not just accommodation, right? That reasonable word is a legal term apart. There's generally three categories or three reasons why the answer to that question is no. First, there's like a list of per se of accommodations that are per se not reasonable, right? That includes eliminating an essential job function. That's not considered a reasonable accommodation. Creating an entirely new position. That's not a reasonable accommodation. Lowering uniformly applied production standards or performance standards. Not a reasonable accommodation. I think the other one is having to provide personal use items to your employees, like providing employees a wheelchair or a prosthetic limb or eyeglasses or hearing aids. Not a reasonable accommodation, right? So category one is there's a list of accommodations that per se are considered not reasonable. Number two, the second category is there's a statutory limitation on an employer's obligation to provide reasonable accommodations. Even if an accommodation could be considered reasonable because it's doable, or on its face doable and would be effective if it was implemented, you don't need to implement it if it would cause undue hardship, right? Undue hardship is this statutory limitation. It's a high bar to meet, however. And basically what it means is that providing that accommodation would cause the employer significant difficulty, a real disruption, or a real financial expense, like a huge financial expense, or it would require fundamentally altering the job, right? If it's an undue hardship, you don't need to provide it. And then the third category, or the third reason why the answer to that question is no, is that just because an employee requests a particular accommodation does not mean that you have to provide that particular accommodation. If you know of one that's an alternative one that's equally effective, but it's less expensive, less burdensome, but it's equally as effective, then that is something you can offer to the employee, as opposed to the initial accommodation that they requested.
I think that's a really fascinating one in particular, this idea that you can offer equally effective alternatives to what they are formally requesting. I'll
Yeah.
say, like at a past job, without going into specifics or names or anything. I remember someone asking for like an ergonomic chair, but the one that they requested was like truly absurdly expensive, and so
Hmm.
a lower cost one, and they were quite upset about that. But the reality was, it did the same job. And I do think it's really important to know that like you have options. This is an iterative process, which we'll talk about. I wanna dig into what, and I see some questions coming in. I'll drop any like big hard hitting questions in the Q&A box so we don't miss it. Just because of time, I'm having to be careful and selective in the meantime. I'm curious to know, a question that I see come up a lot before we jump into like what do you do when someone requests is does the person have to request for you to be legally liable for providing an accommodation? Let's say somebody has a disability, but they don't feel comfortable speaking up, but you're well aware that they have a disability.
Yeah.
What is your obligation there? Or is it like, nope, unless they ask, I don't have to do anything?
Yeah. So it's the former.
Hmm.
Obviously, an employee can formally request a reasonable accommodation, but a lot of times what happens is the employer learns enough information to know that the employee is in need of some change or adjustment related to a medical condition, right? Many employers make the mistake of thinking, well, he, she, they hasn't requested an accommodation, so I have no duty. No, if you have enough knowledge to know that they need some change or adjustment, and that needed change or adjustment is related to a medical condition, the duty to engage in the interactive process has been triggered.
What I think is so fascinating about what you just said isn't, and let me know if I misunderstood, you did not say, hey, you're aware, therefore you must accommodate. If I heard you correctly, you said you are aware, therefore you must initiate the iterative process,
The
which,
interactive process, yes, your
which
duty is triggered when you have that knowledge. Yes.
Lovely. Okay, we're going to talk about that in a second because we had a ton of questions come in anonymously around the employer trying to do the iterative process and the employee not partnering with them, and the employer feeling like, what do I do? They're not doing their
Yeah.
part.
Yeah.
So we'll talk about that. Keep that in the back of your head. Okay, so with that said, let's talk about it. Let's say somebody comes to you, or as the HR person comes to the HR person and says, "Hey, HR person, I would like to request a reasonable accommodation." What do you do? In fact, and oftentimes it doesn't happen that way. What happens when the employee goes to their manager and says, "I would like to request a reasonable accommodation"? What happens?
Yeah, and that's is there's a lot of both. Go to HR first or go to the supervisor first. I will say before I answer that question,
Yeah.
in your policies, in your written policies, you should strongly consider having written there, if employees, if anyone needs an accommodation from this policy, or if anyone needs a reasonable accommodation for disability, please contact HR, right?
Mhm.
We want to try and have HR be the ones who deal with this. I can get into why, but it's preferable to have HR be the ones who administer and process and navigate these reasonable accommodations as opposed to the supervisors or managers. But if the employee goes to any of them, HR, supervisor, manager, any person in management with whom they feel comfortable, step one is that request, right? Step one, and that request, like I said, could be formal. I need an accommodation because I have scoliosis. I need the ergonomic chair because my current chair, flares up my sciatica pain.
Mhm.
Or something as simple as my chair is uncomfortable and I think it's making my sciatica pain flare up. That could be a request for a reasonable accommodation. Why? You know that there's a need for an adjustment, and two, that needed adjustment is related to a medical condition, right? So that's step one. Step two would be to determine, and again, preferably HR, would be to determine if the condition that the person has is considered a disability as defined by the applicable statute. Let's assume the conditions we're talking about today are, because that's a whole nother webinar in and of itself that we could have,
Yeah. Yeah.
right? The next step, step three, would be to ask, okay, what functions of the employee's job is he, she, they prevented from performing because of their disability? Are they essential job functions or are they marginal job functions? And the reason that question is important is because by law, an individual with a disability is only considered to be otherwise qualified and thereby protected by the statute, right? if they can perform the essential functions of their job with or without a reasonable accommodation. The marginal, non-essential job functions can very likely be reassigned elsewhere, right? And you can trade marginal functions. You can give the disabled employee other marginal functions to perform if you reassign the ones they can't do elsewhere, right? But if the job function that they can't perform is essential, then the next step, I think we're at step 4, right, is to ask the employee, what accommodation would you like in order to perform that essential function? Now, we typically do those steps, because I know I just gave you a lot to download. We typically do those steps 2 through 4, right? Does the person have a disability? What are the functions that they can't perform? Are they marginal or are they essential? And if they're essential, ask them what it is they need. We perform those steps typically using a questionnaire, right? I think I saw in someone's question somewhere in the comments, or I forget where, they asked, is there like a one-stop shop that we can use to process these requests? It depends, right? You can have a questionnaire that you use for all requests, and you can tailor it according to each request, according to each, depending on what each employee's needs and disabilities are. That's typically how I would approach steps 2 through 4 there. Once you get that questionnaire back, which is filled out by the employee's doctor, by the way, and it says, what's the nature of the impairment? What life activities does this impairment affect? Here's a copy of the employee's job description. What job functions does the employee's condition prevent him or her or they from performing? Once you get that questionnaire back from the doctor, that's when it's on HR step 5 to determine if the requested accommodation is reasonable. Is it effective? Is it unduly burdensome, right? If it's not, then you can propose an alternative one. But those are generally the steps. Determine if there's a disability, determine what functions they can't perform, ask the employee what they want through the questionnaire, and then step 5, have the interactive dialogue to determine whether what they requested is reasonable or not.
Super helpful. Tons of questions coming in the comments. I won't be able to address them all right now, but I will answer just a few very quickly. One, we will be sharing a template form for anyone who would like this that you can just use for your employees moving forward. And this is also a form that you could leverage in combination with our case management tool, where you would store, right, any documentation and track the reasonable accommodation process, because as we'll talk in a little bit, the documentation process is critical, especially when there are overlapping performance issues. The other thing is just to reiterate, because we had a question, do you have to provide a new role for this person? The answer is no, right? Because this is the need of the business. And if they can't perform the essential role, then that would be undue hardship for the business to create a superfluous role for them. This is the role that they applied for. This is the role they need to fulfill. And I'll give a very specific example, right? You may have seen at some point in job descriptions, must be able to lift 50 pounds, right? At least, right? That is not discriminatory. That is calling out an essential function of the role. And if you would not be able to do this, right, this is unfortunately not a role that in any way we could accommodate, because that's a critical need of the role. Justine, I don't know if you have any other, I know in our audience tends to really love specific examples. So if you have any examples of a specific accommodation without giving names or anything, or something that you've done for someone, or something that made it so that this was undue hardship, so we didn't approve it, anything that comes to mind.
Yeah, so to your point, Melanie, we have to provide reasonable accommodations that allow employees to perform the essential functions of their job. So let's say you hire an employee to be like an investigator. Okay, and the investigators are required in their job description to complete at least 30 investigations per year. Their essential job function is to investigate, right? You would agree? They're also expected to write weekly articles and blog posts for the employer. Let's say employee A comes to you. Employee A has a history of good work product, good investigations work product, but reveals that she has a learning disability, right? And it's getting worse, and she can't complete the 30 investigations per year while also writing, weekly blog posts and articles for the employer. You determine that, these weekly articles and blog posts are marginal, because she still can perform the essential functions of completing 30 investigations, right? and it would not cause you undue hardship to reassign the weekly blogs and articles to someone else, or perhaps make her write one once a month instead of weekly, right? As long as she can continue to perform the essential function of completing those 30 investigations per year. By making this slight change, right, you're providing employee A with the opportunity to perform her essential functions of completing the 30 investigations per year and eliminating the barrier that keeps her from doing that. Now, if she said, listen, my learning disability is so bad, I can only do 10. Well, that's a different story, right? The requirement is to complete 30. We've got a quota to meet, then you're in a different camp.
Love it. Okay. So I'm looking at the time. I'm going to ask you a couple of rapid fire questions, and then we'll jump into the meat of performance management. So super rapid fire. Question. What do you do if an employee does not want to provide or disclose the medical issue that they're struggling with? They don't partner with their doctor, or they keep dragging out the process. So you assign them a deadline, like you must respond within 2 weeks, and they're just like, keep dragging it out. What do you do?
Yeah.
Are you just like locked or what?
No, the employee has just as much of a duty to engage in the interactive process in good faith as the employer does. Neither side can delay or obstruct the process. So, if the employee refuses to provide the paperwork requested by the employer or unreasonably delays that process, then technically he or she or they is not entitled to the reasonable accommodation under law. However, and you'll hear me say this a lot, document, document, document all of your efforts to try and get the employee to cooperate, right? Why? If you go into court and you say, well, I reached out to employee A 6 times to get her to submit the questionnaire and I didn't get a response back, and you have no documentation to show for it, it's not going to mean much at all. Why? Employers are seen as having the competitive advantage when it comes to record keeping and documentation. So if there is no documentation, guess who wins? Typically the employee. So document all of your efforts to follow up with the employee and get him or her or they to cooperate in the process.
Love it. Okay, next rapid fire. How much time do you give them, and how many times do you reasonably have to follow up before saying, you know what, you're not cooperating?
Yeah, no, there's no hard and fast rule. I'm not going to tell you send 10 letters or send 4, right? It really depends on the circumstances. But one hard and fast rule is employers, HR professionals, you should respond as quickly as possible to a request for a reasonable accommodation, right? The interactive process should start as quickly as possible. Why? Because unnecessary delays can result in a violation of the ADA. Sometimes the length of time is outside your control, though, right? Let me give you an example. A supervisor sits on a request from a deaf employee for, adaptive equipment for their computer, sits on that request for 2 months, and then brings it to HR. That's much different than the supervisor or HR ordering the equipment and it taking 2 months to get there, right? The employer has acted swiftly. As long as the employer has acted swiftly, you should be okay. Don't sit on a request for a reasonable accommodation.
Okay, great, love it. All right, next rapid fire, and I think maybe I'll move on. Actually, no, 2 rapid fires. So 1, how many people do you loop in? Do you tell the CEO? Do you tell the manager? Do you tell the skip level? Who do you involve?
Yeah, the general rule is I don't know who said out there that it was scary to navigate their first. I think it was Lynette who said it was scary to navigate her first reasonable accommodation request because all she had was her college education behind her. The good news is the answer to this question is common sense, and it really is college education level. Only share with those who have a need to know basis. Why does the CEO need to know? That's the question you need to be able to answer. If you don't have a good answer to that question, don't share it with the CEO. And the reason is because these statutes protect the confidentiality of medical information. In fact, require that confidential medical information be kept in a separate file than an employee's personnel file, right? So it necessarily follows that an employee's supervisors and managers, let's say, if the employee went to HR, before HR shares this information with the supervisor, ask yourself why. Why does this supervisor have a reason to know? Why do they need to know this information? There could be a good answer to that, right? Maybe they need to be brought into the loop. They need to be told about the necessary restrictions on the work or duties of the employee. They need to be told about the necessary accommodations that are being implemented to address the disability. They need to know these things because they're the person who's overseeing the daily work of these employees. But don't share more than that. You don't need to share with the supervisor that the employee suffers from, X condition. Only on a need to know basis is the rule.
Love it. And that actually answered my next question, which was how involved should the manager be? So you heard it all from Justine, right? As little as possible, only as actually necessary to determine to complete the process. Yeah.
But the reality is that a lot of times the employee voluntarily involves them because the supervisor is the person who the employee goes to
Yeah.
in the first place, despite that you have a policy that says go to HR, right? They don't know, newsflash, employees don't always follow policies, right? All of us in HR
What
know that happens.
did
Yeah,
you
I mean,
say?
right? Believe it or not. And so, the reality is supervisors are often involved because the employees do it voluntarily.
Gotcha. Okay, super helpful. All right, so now, dun, 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 let's talk about performance management. In the comments, I'm not going to call anyone because of time, but I just want to get a pulse check. Yes, no. Do you agree with the following statement? I've never had an employee request a reasonable accommodation in response to receiving a poor performance review. This never happened. It's never happened. Okay, yeah, we're getting a no. No one agrees with this statement. Yeah, everybody has experienced this. It's a very real thing. So before I jump in, Justine, does this catch you by surprise? Are you like, what? I never knew such a thing.
Yeah, what? I've never heard of
Yeah.
that in my life.
Yeah.
Totally kidding. Totally kidding. Happens all the time. The reality is employees sometimes listen, there are plenty of employees that have legitimate needs. Absolutely,
Yep.
completely acknowledge that. However, there are also a lot of employees who try to use a request for a reasonable accommodation as an attempt to insulate themselves, right, from some sort of discipline or termination or something like that. It happens all the time.
Happens all the time. And I really love, Justine, your approach here, which is like there are two sides, right? Like there could be an employee on the other side of this who has been too nervous to speak up or ask for help or didn't know
Yeah.
the process. And until their job was on the line, right, that was the final push to be like, crap, I guess I need to like disclose this thing that feels very personal to me and I didn't want to talk about, right? And
Hmm.
also, on the other hand, it could be someone who unfortunately isn't leveraging the policy as it should be leveraged, right?
Right.
Regardless, we still need to do our duty to see this process out thoroughly and in line with the law. And so my question to you is, I'm curious to know, how should employers balance ongoing performance issues with accommodation requests? And so the very specific question is, what does an HR person do when the manager comes to them and says, I just gave them their perf review, I told them they were underperforming, and now they're requesting a reasonable accommodation? What do you do? Do
Okay.
you no longer performance manage them?
I'm gonna back up before that
Yeah,
point
please.
because there is and this is going to be a little bit of a long answer. I'm going to try and keep it as short as possible. The best starting point for any of us here as employers, as HR professionals in any situation is to have a core performance management process and system in place that consistently, uniformly, and regularly applies to all employees, because performance management, if done effectively, right, can help avoid claims of discrimination, not just disability discrimination, but all discrimination, because it provides documented, contemporaneous reasoning behind why we are taking a certain adverse action. It takes away that room for interpretation, the room for the employee to come up with their own reason as to why they're being subject to an adverse action, right? Well, it's because I'm disabled. It's because I'm being regarded as disabled. It's because my sexual orientation is because of this, that, the other, right? It also has the added benefit of furthering your business objective by holding employees and their managers accountable. Have a performance management system in place that clearly and explicitly defines performance expectations in writing, clearly defines how performance is measured in writing, provides regular, right, keyword regular, and reliable performance feedback in writing, and is consistently applied to all employees in writing, right? Because an accurate assessment of employees' performance from day one, sure, could the employee be alerted to the fact that they have performance problems and their disability could be the cause of it? Sure, but it's less excusable when they are confronted about a performance problem 4 times before they bring up the fact that it's their disability causing it, right? If you go to terminate someone for some performance problem, and this is the first time you're addressing this performance problem with them, and in turn, this is the first time that they're bringing up their disability to you, you may need to accommodate, right?
Mm.
Certainly, if you had a core documented performance management system in place where you had 3, 4 check-ins with this employee throughout the year or 2 years you've been with them, you would have confronted this performance problem with them that you now need to terminate them for. If they bring it up for the first time, then you still may be able to go through with the termination without accommodating them. But if this is the first time you're confronting them about a performance issue, and this is the first time they're bringing up their disability, right, or the request for an accommodation, you may still have an obligation to accommodate.
Fascinating. So I'm going to say for everyone in the comments, because Justine, you got a ton of love when you were talking about like the performance management process and so on and so forth. Um, I give me a +1 in the comments if you're curious. I'm just, or if you're interested, because I will share. And if you are interested, we can send this in our follow-up email. We have a deck all about how to define performance at your company, and also we have a template for performance reviews, and so we can share that for you so that okay, we're okay. Lots of interest. So we'll make sure to share that in our follow-up, so that, to Justine's point, you can have very clear documentation. We literally go so far as to color code our feedback so that there's no room for misinterpretation. So like yellow is nice to have. Orange is if you don't act on this, you can't get an increase or promotion. Red is danger, danger. Your job is at risk if you don't meaningfully improve this feedback. So it's a very robust process. I'll share with you all, but low left as well. I'm curious to know, Justine, so let's say someone does find themselves in the position where they're not about at the point. So actually, let me clarify. So you're saying that if you have robust documentation and you're just about to terminate, and they say, I would like to request a reasonable accommodation, depending on your documentation, you may already have enough information to say, it's too late. We've been working on this for 3 months now. We're terminating. That's, I think, very helpful for, again, consult a lawyer, case by case, but like, helpful to hear. I think most people wouldn't know that. I think most people would say, crap, now I can't do anything, everybody freeze. Now
Yeah,
let's
not
say,
necessarily. Depends on what you just said. Yeah.
right, okay. Now let's say by chance someone's on the other side of things where they just started giving tough feedback and now
Yeah.
somebody requests it. They're at the beginning process. I'm
Yep.
curious to know, very like tactically speaking, do you now pause all performance conversations, or can they happen in tandem? And if they can happen in tandem, how long do you have to wait after the accommodation has taken place to determine if you're no longer willing to continue partnering with this person?
Right. Yeah. So you can so instead of termination, now we're talking about something like discipline or a negative review, right? The purpose of those things is to do what? Is to improve performance, right?
Mhm.
And a reasonable accommodation is always prospective, right? So you're not required to excuse past misconduct or past poor performance, even if it resulted from the individual's disability, right? However, because we're now looking forward, discipline or a negative evaluation, and the point of those things is to improve performance, because we're looking forward now. Now that begs the question, okay, what does the employer need to do to accommodate this individual so that they can improve their performance and perform the essential functions of their job with or without a reasonable accommodation, right? The discipline or the low rating is based on performance having nothing to do with their disability. We
Mm.
didn't know about their disability. We didn't know about their need for a reasonable accommodation, right? So no, you don't have to rescind the discipline or rescind the negative evaluation, but you may have to change things going forward, right? So let's say the discipline you issue someone is a 60-day PIP. If you don't improve upon X within the next 60 days, within the next 30 days, we're going to have to issue a final warning, or we're going to have to terminate. Maybe the request for an accommodation is a little bit involved. It's going to take a little bit of time. So you increase that 30-day PIP period to 60 days or to 90 days to accommodate that individual's need for something that will, a slight change or adjustment that will allow them to improve upon their performance. To answer your second question, do we stop all performance management going forward? Absolutely not. You just might have to slightly change how or when you do it.
Super helpful. I think in particular that key that maybe you just extend the timeline to
Yeah.
accommodate the fact that the iterative process may take some time. I think that's monumentally helpful to most HR people out there. So thank you very, very much for sharing. I have one very quick tactical question, and then we'll jump into the next portion of this webinar. I'm very curious to know, there is the very formal iterative process when my understanding is when there's like a meaningful thing that they are asking to accommodate and you're like, whoa, 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 we need like a doctor's note, so on and so forth. And there are separate, and let me know if you disagree here, I'm talking to a lawyer here, right? There is separately, someone may say, you know what, I'm going to disclose that I have ADHD, for example. And to be honest, it's actually very difficult for me to focus if I only have verbal communications. And so I'd love to have things, I'd love to have closed captioning or things in writing. And you can choose as an employer just to say, okay, fine, we'll do that. We don't need to do an iterative process. I'm curious to know from your perspective, is that a dangerous thing? Like, no, no, you should document that. Is that like, no, no, we're not going to take any action until we have like a doctor's note? Or is it, no, no, we'll do this. And also you still need to give a doctor's note in the meantime. Like, I'm curious to know how what people should think about as they're balancing things they can do without a doctor's note, things that they should do with a doctor's note.
I'm going to give you the most lawyerly response ever. It depends.
Okay, love
Okay.
it.
It
Tell me more.
depends. But,
Yeah.
but your question is, what should they be thinking about? The number one thing you should be thinking about is what precedent am I creating?
Mm.
What precedent am I creating? Because as an employment lawyer, what am I focused on? I'm focused on what can have the appearance of discrimination. Right? Why are we treating employee A who has ADHD one way and not requiring a doctor's note, but employee B who has ADHD, we are requesting a doctor's note. So again, the reason why the answer is it depends is because there could be a good answer to that question. Sometimes disabilities and the need for an accommodation are obvious, right? Sometimes they're so obvious that you may not need to send a questionnaire to the doctor. Let's say you have an employee who has asthma. You've seen them several times, like take an inhaler after having an asthma attack, right? Pretty obvious that they have asthma. You may not need to get a doctor's note. You may not need to get a questionnaire filled out by a doctor to say that they need like a humidifier in their room, right? But it really does depend on the situation. There's really, unfortunately, no black and white answer to that.
I honestly think that's so helpful though, to think about from the perspective of like, you may be setting a precedent that opens you up for like, you maybe did it from a place of good intent. You thought this was a good thing, and now you're opening yourself up to liability down
Exactly.
the line. And so I think what I'm hearing is if it's a thing that is obvious that you like, the purpose of the doctor's note is to verify that this thing exists. And so if you feel like you can verify that without a doctor's note, like for example, someone is 8 months pregnant and it's showing, and so you're going to let them work from home for that last month, right? And you're okay, fine. But like if it's something like a neurodivergence, that may be something that actually you shouldn't action on unless you can, again, it depends, but like that may be something that you want to document versus just making the accommodation.
Right. And by the way, if you're not quote documenting by getting the completed questionnaire, getting the doctor's note, you should still document what you did. You should still
Mm.
document the knowledge that you have, just the facts. Don't make conclusions of law. Don't say this person suffers from this. What are the facts you know? This person has had several asthma attacks over the last year. They've told me that they will do better with a humidifier in their room. Doesn't cost much. We're going to order the humidifier and see if it helps the situation. Document what you did. They came to me on X date. I ordered it on Y date. They had it in their office on Z date.
Lovely. Okay, all. Let's pivot real quick. As I mentioned, we're going to do a quick Athena spotlight, and then we'll open it up to Q&A. You will ask so many questions. I'm gonna be honest, we're not gonna be able to get through them all, but what we probably will do is look into doing some sort of follow-up, whether it's in writing or a part 2 webinar, if you're down for it, Justine, because there's lots coming in, and it's very good stuff. So with that said, quick spotlight. I do want to highlight that, is this in the right order? I'll go in this order. Okay, we talked at length about the importance of documentation. So I do want to be clear, you need to document. If you are interested, Athena has a case management tool where you can track all of your employee relations issues, whether it be performance management, reasonable accommodations, as Justine mentioned, all of this ties in together. You want to have robust performance management tracking. If someone is on a PIP and having performance issues, you want to have that documented and in writing. So you can upload, track, maintain all ER records. It also comes with robust reporting analytics, so you can track, are we seeing trends in more accommodation requests? Are we seeing trends in performance issues based on X, Y, or Z? That way you can really clearly track, as anybody who works with the CEO knows, they live on metrics, okay? So you want to be able to provide hard numbers for everyone. And finally, it actually also comes with a free employee hotline tool. So in addition to all of this, it's a tool where your employees can anonymously submit reports if they have any, and you can collect them. You can also auto route cases by category, so only some teams get it, or like the very specific HR person in your department who manages this gets it. So anyway, I'm sharing that. And then lastly, going back one slide, actually, I wanted to talk about, we talked a little bit about the manager and the role that they play. It is very important that your manager not put their foot in their mouth and maybe ask for more information than they need, or maybe they don't bring it to HR when they should have. To your point, Justine, what if they sat on that feedback for 2 months before escalating it to HR? That could put you into very hot water. And so we actually have a training for managers all about the legal do's and don'ts as a manager, including how to navigate reasonable accommodations as a manager, up to and including don't get too involved and immediately loop in the HR team. So if you are interested, let us know. We do offer special discounts for webinar attendees. So if you're interested, keep an eye out for the email that we're going to send post-webinar for more details. With that said, all here are the SHRM and HRCI credits for anyone who tuned in for that. While that's going, Ace, could you put up the poll? Before we do our Q&A, we always like to ask you a couple of questions. We'll leave this up for 10 seconds. I'll be quiet, and then we'll do Q&A. You will have a ton of them. Oh my gosh, shout out to Jamie Anderson. Hell yeah, customer. Athena, actually, I'm gonna do something we never done before. I'm just curious. If we have any Athena customers on the call, can you give me can you say Athena customer in the comments? I'm just curious to know how many Athena customers we have on today's webinar. Yay, I love seeing Athena customers. Welcome, welcome. I hope you're enjoying the webinar, and we hope that you enjoy our trainings and our case management and hotline tool. And if anybody's ever curious, listen, you got people right here that you can ask for the inside scoop. Is Athena actually helpful? I hope so. So with that said, we can go ahead and close the poll, and let's start asking a couple of questions. So I'm going to start with like a hard-hitting one. Justine, we got a ton of questions about neurodivergence. It seems to me from the questions and also from what you shared that there's been a spike in people sharing or requesting reasonable accommodations due to either mental health issues or neurodivergence challenges. In particular, ADHD is a really common one. And I'm curious to know from these employees, anything that people should keep in mind when navigating a neurodivergence disability versus a physical disability where there may be a very clear-cut accommodation.
Yeah. So following the statement that I'm neurodivergent, I suffer from ADHD, whatever it may be, usually what follows is, can I work from home? Right. And to me, the question that I ask clients when that comes up is, okay, let's figure out why they want to work from home. They're neurodivergent, they're ADHD. So what does their disability prevent them from doing? Their disability prevents them from perhaps focusing. Their disability distracts them, right? So we don't want to let them work from home for whatever reason, whatever it may be. Is there an equally effective alternative reasonable accommodation? Yeah, there's plenty. Here's one example. Can we move them to a quieter workspace to lessen the distractions? Can we have their supervisor provide more structured assignments? Can we have their supervisor provide deadlines? Yes, it's a little bit more, it's inconvenient, but with great power comes great responsibility, and supervisors do have to do these things sometimes. And in some situations, in some scenarios, when an employee doesn't get their request to work from home because of their neurodivergence, they'll just leave. Right? As long as you've offered them an equally effective alternative reasonable accommodation, which a lot of times there are, you've fulfilled your obligation, right? Can, a lot of times you just have to ask yourself, can their essential functions be performed at home? Can they? Yes. But can they be properly supervised if they work at home? A lot of times the answer to that question is no, right? And so is there an equally effective alternative accommodation we can give them, like being in a quieter room or having their supervisor provide structured assignments? That might be one way to tackle a neurodivergent employee.
Fascinating. Quick follow-up question. When it comes to like a mental health situation, oftentimes, and I'm seeing these in the questions, so these is not just me throwing this out there. What I'm seeing is that a lot of people are struggling with a situation where somebody discloses that they have a mental health issue, but they don't necessarily have the backing by a medical provider. They don't have language from a medical provider to provide. What is the company's obligation at that point? If someone says, I have mental health issues and I need either time off, or, I can't start work until 1 p.m. because I, have sleeping issues, or, and I'm not, by the way, like, let's take it at face value, but if they can't provide or they don't provide medical proof, what is the company liable for?
Yeah, so an employer has a right to ask for reasonable documentation to substantiate the existence of a disability and to substantiate the or the need rather for a reasonable accommodation. If the employee is refusing to engage in that process, technically they're not entitled to protection under the law. Now, I would maybe meet with that employee and I would say, is this, look, it's easy for us to say work is stressful. Work is making me feel depressed because my caseload is so high, it's so stressed. That doesn't mean that I have a disability, right? You are entitled to ask for that documentation. If they refuse to engage in that process, how can you substantiate the existence of a disability and their protection under the statute in the first place? Some employers have healthcare professionals that they work with directly that they will send employees to for things like fitness for duty evaluations. If the employee, let's say, doesn't have the money to pay for a doctor's appointment, something the employer might consider is, okay, well, we have a medical provider who we send employees to for this sort of thing. It would be at the employer's expense. Can we have this medical provider, do an evaluation of you so that we can have a completed questionnaire? It's our policy to substantiate the disability and the need for a reasonable accommodation before we give it.
That is fascinating. We actually, so we're at time. So it looks like we have a ton more questions. Justine, I want to be respectful of your time. I know you have a hard stop. So, thank you so much for the questions. I promise you they're not going nowhere. We're going to take a look at these and see if we can do either a follow-up or a summary. Maybe we do a blog post where we answer these questions. Justine, thank you so much. I don't know if you can tell, but the comments are wild. They're loving you. It's really, really genuinely helpful. And I really want to thank you in particular for being so inclusive in your language around pronouns and thinking about, the costs that somebody may that may come with having to substantiate a reasonable accommodation request. Really, really thoughtful and lovely approach. Everybody give Justine a shout out. Thank you so much. And there will be more webinars. Keep an eye out for our email follow-ups. Thank you so much for tuning in. Give it up for Justine. Thanks so much.
Thank you, guys. Thanks, everyone. And just hang in there. I know. Keep fighting the fight. Hang in there. I know it's tough, but we're going to get through this.
Thank you all. All right. Bye. Have a good day.